So I am delighted to be joined today by Simon Anderson, who generally made me laugh this morning with some comments on LinkedIn about grouse shooting, but we'll see if we get onto that. But particularly, why I wanted to talk to Simon was his fairly ingenious, and I'm going to censor this title for a podcast, which is the myriad and ingenious ways employers mess you up. Simon, would you like to introduce yourself?
Hello. My name's Simon Anderson. I'm a barrister at Park Square Barristers in Leeds. I specialise in psychiatric injuries, but in particular, occupational stress. I suppose really my broader practice is industrial disease litigation, but occupational stress really is my specialisation and my niche interest. And I think you and I were just having a brief conversation before we hit the record button about how each of us came into our respective fields. But for me, occupational stress really came about as a result of conversations with people, but one particularly stands in memory. An Employment Law Association dinner many years ago, somebody sitting next to me said how much he hated occupational stress work, wouldn't touch it. And that was my epiphany. That was the moment at which I thought to myself, no competition. Nobody wants, and the reason nobody wants to touch it is because the narratives. So ordinarily in personal injury work, car goes into the back of another car T-bones another car, person falls off ladder. It tends to be quite a short narrative to how the accident occurred. In occupational stress work, that narrative can last years.
I hadn't thought about that. Yes, yeah. Makes sense.
And people don't like those long, complicated narratives because they don't know how it plays out.
And I mean, all cases are individual, aren't they? But I bet these are particularly layered instances of some spectacular decisions and comments made. I've no doubt. You know, we all work with people,
and it would be untrue if I was to say that I don't, from time to time, feel sympathy for the employer. Okay? Occasionally, I come across those cases where I think to myself, I can imagine this person was quite difficult to manage.
Yes, and you know, I always say, and I can say this because I am a lawyer. So you know, anybody listening, you know, don't have a go at me. I think as personality types, we're quite interesting, aren't we? Because we're trained to be difficult, we're trained to argue, we're trained to poke holes in things, and that can bleed into working with each other. And you think we know better, wouldn't we? You know, because we go, maybe I shouldn't, you know, and again, possibly we're not trained to do the sort of, you know, leadership management part, and you find yourself in that space anyway. And when you're working with lawyers who are by nature difficult and argumentative, it could get quite heated, I imagine.
I've got a great little anecdote for you. About a year or two ago, I represented a solicitor who was neurodiverse and had problems holding down a job. I mean, he'd been fired from just about every job in every firm he'd ever had. I didn't think he could last long enough. I don't think he'd last 2 years, in other words, to qualify for protection against unfair dismissal. And he just kept on finding himself dismissed or compromised out of the business. And he came to me with a claim for disability discrimination and harassment. And the more I spoke to him, the more I realised what his problem was, which was that he was normal for Yorkshire. And I actually joked him and said, have you ever been to Leeds? He said, well, yes, my girlfriend went to university in Leeds. I said, well, what did you make of Leeds as a town? He said, I really liked it, and I really liked the people. I said, did you find that you fitted in? She said, well, yes, I did really. So, and I think that's because your problem is that you're very direct. And in Yorkshire, we don't take offence to that sort of thing. But your problem is that you're in Kent.
It's interesting you say that because our firm has multiple offices and we'd opened the Bristol office just coming up a year ago, and trying to explain to people, saying people in Bristol is not like Birmingham or London. It is a very different city, and it is interesting understanding that demographic piece as well around that. So it's quite informal down here. A really nice collegiate sort of environment with the lawyers. As a city, we're pretty good to look out for each other, and actually fairly friendly. Which I think sometimes people go, "Oh, you're a bit too friendly." I'm like, "No, it's fine. We don't need to be aggressive and difficult,
Yeah.
in that respect." So, yes, how an interesting. Have you just thought about moving counties? What great advice.
I didn't quite pitch it in those terms, but I just sort of plant the seed by that. Maybe the problem isn't you. Maybe the problem is where you are. I actually thought it was delightful, and I had some sympathy for the employee because I could understand why, when you have somebody as direct as him, and with a condition that makes him, shall we say, inclined to observe the rules and identify those who don't observe the rules, how that can be quite frustrating. But you are lawyers.
Our lawyers. Yeah,
You are in a rules-based system.
yeah. So this is a law. I'm going to apply it. Sorry. You may not like it, but there we are. Um, how fascinating! How fascinating. So, occupational stress. We open papers. If people are still opening papers these days, online, we're seeing lots of things like mental health and difficulties. And you mentioned neurodivergence, and we're getting better at understanding these things. And I do a lot of work with mental capacity,
Mm,
which is also a curious world because it is task and time specific. So
mm,
if you sort of thinking you use that sort of thinking, you can apply it to lots of other things, even if somebody doesn't have an impairment or an impediment or a factor that actually would constitute, as you say, a disability per se. So what should we be doing apart from obviously sympathetic head tilts when somebody comes in and goes, I've got a problem.
I think one of the main distinctions between mental capacity, and mental health, has been that one has never really had much of a stigma around it. We accept that capacity or the loss of capacity is something that tends to happen with age or injury. Whereas with mental health, it's long had that stigma around it because people associate it with madness or vulnerability. It's come with a great stigma. And this century, we've really seen the destigmatization of that around conversations, I suppose, as you say. And I think it's really helped to have a young royal generation talk openly about this as something that needs to be destigmatized. And having, say, for example, a heavyweight champion of the world in Tyson Fury willing to talk about his own mental health struggles. So, in a sense, we're already partway there in that we acknowledge that there, but for the grace of God, go any one of us. And there's also what I call a bit of a vulnerability paradox at play. Those who project in vulnerability tend to be the most vulnerable. And those who accept their vulnerability tend to be well inoculated against mental health trouble. And I think really that the most helpful thing any of us can do, particularly in the employment context, is just recognize that we all, from time to time, all of us, at some point in our career, will need some support. We will need some accommodation. We will need some latitude. And so when my senior clerk came to me asking me about the circumstances of somebody requiring compassionate leave some weeks ago, there was no issue. He didn't need to give me the details. I said, no, I really don't need to know the particulars of this person's particular difficulty. If in your judgment this person requires compassionate leave, we give it because they need it, they deserve it, and it certainly projects the correct image that we would wish to project as an employer towards our workforce, that we care.
I always used to say, believe it or not, we are human, and we all have lives outside the work environment. And I sort of used to mentor people and juniors say, look, this job is tough enough without having to go at each other. So if you've got a problem and we want to sort it, we talk about it, or you leave it outside. It's one or the other. And
Yeah,
you don't sort of come halfway with this. If we can fix it and talk about it, we understand where you are, we can accommodate and make those reasonable adjustments. Or you don't want to talk about it because it's too personal, and that's fine. Just let us know. And sort of, I've always found that so I had certainly people who would tell me everything, and I'm like, there are limits to what I can do. I can go there, which I used to get told off for. They're like, seriously, is that as good as it gets? So well, I said I can have solutions, but I'm not very good at the sympathy bit. I'll find you somebody who's good at that bit. I've had great relationship with that particular person because she was like, well, at least I know what I'm getting with you.
yeah. We've got an expression. I call it Yorkshire sympathy. Uh, I can give you one of the best examples I once saw of Yorkshire sympathy, which is a child involved in a fell race. And if you don't know what a fell race is, it basically involves running to the top of a hill as fast as possible and throwing yourself down in the hope that you come first. And
Yeah,
it's
we've got
great.
cheese rolling down here.
Yeah, well, imagine that, but dressed for the occasion, wearing studded shoes and all the rest, and doing it for as a race. And this was Burnsill Fell Race many years ago, and a young lad, must have been 7 or 8, coming down the hill, face planted in a ditch, and I mean face planted. Got up, and his dad just happened to be on the other side of the ditch, shouting, "Get up, son!" And I can still remember turning to my wife and say, that's Yorkshire sympathy.
I was
I,
like, has this person met my mother? So my
yeah,
mother was a teacher, and her view on me growing up was like, are you ill? Do you have cholera? Is your leg hanging off? If not, you're fine. Crack on.
as my mum once said to me, the best way of determining whether or not you're fit to go to work, and this was some years ago, is if a £20 note blew past the window, would you run out and chase it?
Yes,
If the answer is yes, get to work.
exactly. But I think our parents are allowed to do that, aren't we? But I think as employers and colleagues, we have to be a little bit more circumspect, perhaps.
I think
What's
so.
your what is your experience of and I know you've got experience because you sent me some absolute corkers of
Yeah.
incidents that you've come across.
Oh, I mean, I, I really should write a book. I feel as though I could be to occupational stress what James Herriot was to veterinary medicine. I've got, I've got some great ones. Uh, I, so, if you might imagine, occupational stress can manifest itself in many ways, from overwork, bullying, harassment, mismanagement. But some of the most amusing and beguiling stories really are of harassment, particularly really assaults. And they shouldn't be amusing, but I'm afraid they are quite often, because the victims didn't quite clock they were being bullied until quite some way into the story. And I can still remember listening to some of these stories and thinking, what part did it occur to you that you were being bullied? In other words, why didn't you appreciate
Yeah,
on day one? But one of my favourite ones was of an apprentice who was a young lad, couldn't drive, couldn't drink, an apprentice shop fitter. And as an apprentice shop fitter, that naturally meant that he had to travel and work away from home quite a bit. And that meant that he wasn't necessarily telling his family what was happening at work. But day one, his colleagues went to the pub at the end of day one. Uh, they came back having had too much to drink. He couldn't join them. He was too young. He was in bed asleep when they came in and woke him up with fire extinguishers.
as
Day
you
one.
do.
Day one. And,
Yes, who thought that was a good idea?
and let's just say it didn't get any better than that.
Wow.
And ultimately, and this lasted about 6 months of pretty much daily vile abuse. But it culminated in several of them on Good Friday in a bank, in a bank they were refitting, I should say, crucifying this young Catholic.
What?
And when I say crucifying, what I mean is they got two planks of wood and a nail gun, turned them into a crucifix, got some duct taped into the crucifix, which they then hoisted against the wall, and then
You do?
with a nail gun fixed to the crucifix to the wall, so he was gagged, arms spread, photographed it and put it all over Facebook.
Wow.
Do you know what their boss said? Next time, make sure you're not wearing your work's tops when you do that.
I'm laughing because I'm actually horrified.
It is. I know. I know. And the most beautiful bit of that whole story that I've really withheld was the reason why this happened, which was I said it was a bank refit. Well, client, being such a decent, honourable young Christian man, found 500 quid in cash behind a drawer and handed it to the manager on terms. And when I say manager, not the subcontractor, the site manager, on terms that this had to find its way back to the banking client that had fitted this out,
Yeah.
which, as you and I know, naturally meant that when he came to give evidence, the judge absolutely loved him.
Oh, I'm very
It's one of
pleased
those
for him.
cases. It's one of those cases that you take on a conditional fee agreement to say, I can't lose. I cannot
No,
lose.
no. But it's, John, is it,
I can't lose for two reasons. Firstly, this lad couldn't have made that up.
no.
And secondly, he is so likable.
Oh,
Likable and honest.
just reminds me. I'm sure there was a case when I was doing my law degree that there was that somebody was set on fire as part of an induction ceremony, and they were like, "Oh, that's just what we do around here because it's barracking." And I was like, and they was like, "No, that isn't appropriate."
Yes. And another young lad, again, apprentice bullying case that I once had, started life in a kitchen. And I mean, the bullying was it started out fairly low level stuff. He was being branded with hot tools, for example, given menial tasks you might expect. But I thought things really started crossing a line when he was stripped naked and put in a chest freezer. I think
Yes,
I don't I don't really regard that as acceptable
it's not really
behaviour.
appropriate, is it?
I, I know in some kitchens they might. And I'm afraid what ultimately happened to him, I can't repeat on even on your podcast because it was unbelievable. But the punchline in that particular story is again he hadn't really been telling his parents until eventually he'd had enough and decided to tell his father, who was a police officer.
Oh,
He might not have mentioned that to his co-workers lest he be bullied.
well, indeed.
and, and so that case actually came to me via the police federation because under the terms of their
Ah,
policy, it is a family policy.
okay, interesting.
Yeah. Yes. So he came to me in conference with his police officer father, which I thought was very amusing. Uh,
Indeed, and you must sit there and go, these are just gifts, surely.
yeah, that case settled pre-issue for more money than it was actually worth. That is how enthusiastic they were to make sure it never saw the light of day.
It is interesting though, because I was talking to somebody earlier on today, and they are a charity community interest group, and they're all about social mobility and talking about young people in the workplace today. And we were talking about, I'm quite interested in, what do you talk about? What are you looking for as lawyers? Well, apart from the obvious academics and stuff, there are certain skill sets you need. You need to be able to, talk to people, and you need to have a certain level of resilience, which I know is a bit of a sort of a buzzword at the moment. What is resilience? And so it's always really interesting because we're talking to young people and they are terrified of face-to-face conversations, and often that's what can solve an awful lot of problems.
Yeah.
And the resilience piece, and I think, when I look back at my sort of fondly or with fear, depending on how I'm feeling, but my sort of trainee days, my sort of first day was like, excellent, welcome, good, you've got rights of audience, off you go to court. And I think I did an 8-day finding of fact child abuse case, sit behind counsel. And I was like, okay, well, nobody prepared me for this. And being like, oh, that's just part of the training. And I look back at it and go, well, actually, it was incredible experience, just quite harrowing having to listen to the whole thing. Not as bad as being thrown out by a judge 5 times when I was doing some advocacy. But I didn't die, so I consider my resilience it has been improved by that
Were you the
experience.
victim of judicial bullying?
I couldn't possibly comment. But there's clearly, as all these things, there's grayscale, there's lines, there's fine lines, and obviously, we have these appalling circumstances that, as you said, and the right outcome was granted. Where do you go from that? It's like, well, this is just normal for your chosen profession. The ribbing, the barracking, the induction, through to, you really ought not to be crucifying people.
Yeah. At what point in your uh, thought process does it occur to you that is a good idea? That
Yeah.
that I tell you a really good example that's unfortunately quite commonplace is that there may be a management mantra. I've heard it. I haven't come across it too often. That goes along the lines of, if you can't pay someone off, piss them off. And I've seen this time and time again in
Mm,
organisations where it may be quite expensive to terminate somebody's employment because of the longevity of service. But with that longevity of service often comes a really good track record of performance.
mm,
That there will be a history of, and hence they've been in the organisation for so long, but very good performance development reviews, one-to-ones, feedback, and so on. And so they're good attendance records. They may have survived rounds of redundancy, and so there's a reason why they've become part and parcel of the fixtures and fittings of any business. And the business finds that it needs to restructure or decides that a new director has come in and wishes to make their mark on the organisation, has to get rid of somebody, suddenly finds that the particular employee is rather expensive to dismiss or make redundant. And I've seen instances of organizations or individuals turn on people who are too expensive to dismiss and really behave very oppressively towards them in a way that discredits the organization, frankly, is dishonorable. But in each and every example, I usually have a client with an exemplary record. So the employer suddenly turning on the individual looks incongruous. It looks as though it was engineered, invariably because it was. I find those cases really quite, well, I suppose, depressing, upsetting when you have such a decent client, somebody who's truly, decent, honourable, salt of the earth. If there were McDonald's, they would be employee of the month every day of the week and twice on a Sunday. You know the kind of characters I'm talking of. And so when you see that sort of what's essentially a conspiracy, uh, that really does nothing for your faith in humanity. But you may or may not appreciate that with a lot of occupational stress cases, the hurdle that you first got across is proving foresight of the risk of harm.
mm.
And with a lot of those cases, there's no difficulty because where it appears that there's some sort of conspiracy to put as much stress on an individual as you possibly can so that they ultimately crack and leave the organization, you cannot then complain when they do crack. if you
Yes.
if you've tried to break somebody, don't feign upset when you succeed.
Indeed, and I've seen it referred to as the scapegoat. That the you know that high performer is is a problem for whatever reason, as you say, it's a new broom, it's all that, and it, for a lot of people, and again, this is something else I was reading, is that a lot of people go, well, even when I'm a retired solicitor, barrister, surgeon. It very much becomes your identity, and so if you're dismissed or forced out or scapegoated in the course of your employment, it can be very damaging, I would imagine, to your sort of sense of self-worth.
And dignity. You know,
Mm.
it won't surprise you to know that in a lot of the schedules of loss I draft, there tends to be a claim for loss of congenial employment. Because if somebody was a career, well, there's authority on the point, but believe it or not, a career prison officer who succeeded in getting an award for loss of congenial employment. Now, you and I might not think that being a prison officer is congenial. We might
Each
consider
their
being
own.
a landscape gardener or an outdoors instructor being congenial employment. But no, uh, if that is your career and if you have ambitions of seeing it through to the end and collecting your full pension and be able to retire with some sense of dignity and accomplishment, then yes, that is a loss of congenial employment.
Which is which is an astonishing place to find yourself, isn't it? And I wonder, this is me being a bit controversial now. Like, I wonder if lawyers are particularly, prone to this because we know how much we can push people who go, I'm not going to do litigation because I'm too tired. I know it's not going to go well.
Yeah, I also sometimes wonder about the extent to which our capacity to operate under stress is unique to us as individuals, or if it's a generational thing. The Gen Z are really copping for it at the moment, as apparently being a bunch of, I think the term is snowflakes, which
Yes.
isn't really what I'm seeing on the ground.
No.
What I'm seeing is a remarkably talented cohort of individuals who, frankly, if I was in their group, I wouldn't succeed today if I was in
No.
competition with them.
I so particularly I think today's SQE results day, and I was like this. There is no way. There is no way you would get me qualifying as a solicitor if I had to go down that route.
Yeah. I look at my now 19-year-old, soon to be 20-year-old daughter and think that she is so superior as both academically, intellectually, emotionally, and all round as a human being than I was when I was her age.
Oh, it's marvelous. You've done a good job.
She just is. And so I really don't accept this sort of generational uh, difficulty with mental health or suffering stress. I do wonder this though. I don't know about you, but I need stress. As in, I really do need stress. So
Yeah.
when we went into lockdown, week one, 2020, Boris says, right, all stay at home. And I think he made that announcement on the Monday. On the Friday, I was in tears. And I remember explaining to my wife that I don't know how to function without stress. I don't know what to do. I mentally and physically need that sense of stress to have that impetus. I've got a trial on Friday. It is stressful. Good. It's supposed to be stressful. It's not supposed to be a picnic.
No,
And the
no, and
stress is what makes me prepare.
yes. I often wonder about the difference between stress and pressure. And at this
Well,
point, I sort of think, is pressure is something you put yourself under? Stress is what you don't have control over.
to an extent, but I think it was well explained, really. Brenda Hale, Baroness Hale, who's one of her brooches actually appears on the wall behind me. Pure coincidence. I should name drop there. But in a 2002 Court of Appeal case, explained that the difference that stress is commonplace and that some stress is good for you. I think really she was referring to pressure. But that we all respond differently to stress, and we can't necessarily predict what that response will be. In some cases, it will be healthy. In some cases, people require that sense of impetus, and in some cases, it will be wholly unhealthy. And some of us choose stressful occupations, and some of us avoid them. And
Nobody going into law is looking for an easy life. I can guarantee that. And we're all told, go, don't become a lawyer, it's terrible. And then, go, I actually quite like it. I quite like, the cut and thrust. And, yes, just very quiet August with the courts in recess. I've had 4 court hearings, which I thought was outrageous. And each one went very differently. And you think, but it doesn't matter how much pressure, how much preparation or presentation we did for this, it's out of our control at a certain point, and you have to then accept that. And I think, as I said before we sort of start recording, I have a slightly mixed bag practice in that I do sort of non-contentious work with clients sitting down nicely and talk about tax planning and what have you, through to contentious court protection. So you got the incapacity point at that point, and it's endlessly fascinating seeing both sides of it, because I think I can correlate both and go, look, if you do your job, if I do my job properly and get your paperwork right, you won't end up in court.
yeah, yeah.
But you're in court because this wasn't done, and then you can use that to go, well, actually, maybe we can tweak this to say, well, there are ways around it. And I think it's really important to have that sort of, this is what happens when it goes wrong, and this is how we fix it.
And do you think that it's that sense of accountability in our work that makes us raise our game, that makes us the professionals that we are?
I mean, it could well be, couldn't it? We understand our regulatory requirements, offices of the court and our council, SRA, and so on and so forth. But actually, that sort of, I think that innate sense of want to do the right thing,
Mm-hmm.
and we'll all say, oh, a sense of justice. But when you're talking about cases like, some poor chap who's been crucified, and you think, this is awful. This is genuinely awful and should not have happened to anybody. And you wouldn't want it to happen to your daughter, your friend, or anybody. And the fact that it did isn't acceptable.
Mm. Mm.
And I think it is important, therefore, that we do sort of stand up and go, I know lawyers, snowflake lawyers through to, fat cat lawyers get a bad rep. But ultimately, at some point, we're going, well, we're just applying the law. We're just doing, what's supposed to happen. There are rules. You break them, there are consequences.
I tell you what I'm seeing a lot of at the moment, which I'm quite enjoying in terms of on the theme of accountability. It depresses me and makes me embarrassed for my entire gender when I see this. But I'm seeing a lot of young women coming to me bringing harassment claims that could potentially have been brought in the employment tribunal, but they're also capable of being brought as Protection from Harassment Act claims. In other words, that there may have been an assault involved, but there's a common theme in all of these. And I'd be fascinated to know if anybody else has experienced this, particularly in employment law. I'm seeing a lot of cases where young women have had hotel room numbers texted to them. Yes. A surprising, it is a surprising phenomenon that on away days, whether in this country or abroad, they are finding that their managers are of the view that it is acceptable to text a hotel number.
Again, why anybody would think that's acceptable? But then again, at the same time, if you're starting out and you don't, you might think, well, what do I do with this? I mean, it's not doing any harm, is it? If I just ignore it or delete it, it's one incident, and almost wonder if it's that sort of boiling frog mentality of going, you don't realize it while you're in it, and then suddenly the escalation point.
Yeah. And those cases really did escalate far beyond merely a hotel room number and were quite vile. But it's that sense of lack of accountability. I think the individuals, the men probably think to themselves, well, we're away from the office, we're away from our homes, we're all adults. If I wish to send you my number, then there's probably not going to be any sense of accountability here. It's not as though I'm doing something that is beyond the pale in the office. And yet, in each instance, what was amusing was that they deleted the text. And in each instance, what was equally amusing is that the women had the wit, even after consuming alcohol, to know to take a screenshot of it. So what could be more incriminating than the claimant having a screenshot and the defendant not disclosing his original and claiming not to have sent the message.
Yes.
Nothing betrays your motives more.
I have this innate fear drilled into me by my supervising partner was a trainee going, never write anything down. You don't want it on the front page of the Daily Mail.
Yeah. My wife's got a similar sort of mantra, which is don't put anything in an email that you'd be too embarrassed to hear read out in court.
Yeah.
Quite good advice when you think about it.
Excellent advice.
Speaking about her, I just remembered one of the other little anecdotes that I shared with you about an overwork case between her and a comparator. I came across a great overwork case a couple of years ago. If you might imagine, my wife was negotiating terms of exit from business. They were putting her through what was really a contrived redundancy exercise. She was one of two people in a pool of two. And in each case, one had half of the country. So she had the east part of the country and her comparator had the west. And they've both been complaining quite vociferously about occupational stress following a restructure and insisting there be risk assessments and so on and so forth. And their director was having none of this and decided that they were going to exit the business. What their director and the business SLT generally hadn't appreciated was that they were both my clients.
Ah.
So what wife, I was negotiating terms of exit. Her colleague on the other side of the country had a breakdown, and he was my client for the purposes of a then inchoate occupational stress case. So what happened in that case is I had his contract of employment and I had her contract of employment, and they were word for word identical, except he was paid 23% more than her.
Marvelous.
And the contracts had only been written 18 months before because they had both survived a previous redundancy exercise before that director came in. Yes, so they survived a redundancy exercise in which 4 roles were condensed into 2. It's quite stressful, you might imagine, doing the work of 2 people. Four into 2. The director left, a new director came in, and wouldn't accept that the 2 incumbents were stressed. So when I noticed that he was paid 23% more, I had that conversation. Darling, did you know that you were paid 23% less than your... Really? That was her on the warpath. But in the meantime, she filed a grievance, and the employer didn't have the wit to appreciate that I might be, shall we say, riding 2 horses, and came back and explained all the ways in which her comparator was doing far more work than she was. None of which was legitimate, because none of it was referred to in either his role description or his contract of employment. This was work that was being piled on additionally. And all I did was take that response, cut and paste it into his particulars of claim, alleging what the employer knew about how much more work he was doing than his female colleague. Now,
happy days.
I won't embarrass her by telling you just exactly how much back pay we managed to extract from the employer, but let's just say it was close to 3 years' salary.
And there you go.
Yes.
That's why you should get good legal advice.
So there is a moral of this story, and to any employment lawyer listening, it is this: never ever settle a case for a female without first asking her if there is a male comparator, somebody in a similar role, whose pay details you can seek disclosure of. Because if the employer says clear off, you know not to settle. And if the employer discloses with some justification, then at least your client then has the peace of mind of knowing that actually there wasn't a latent equal pay claim there in the background that she's just settled. Well, because how can you possibly settle an equal pay claim in any compromise agreement without knowing what the comparator earns.
Yes.
You can't. You
Makes
simply
complete
can't.
sense. And
And,
now you're supposed to out in small words, big print. Beautiful.
I think it's almost remiss of anybody to do that. I really do. You can't advise any client to compromise a potential equal pay claim without knowing what the comparator earns. And that was just one of those unique, beautiful stories of finding something out you otherwise would not have done had you not had both contracts side by side.
Yeah. Well, Simon, absolutely fascinating. And when you're not badgering local gamekeepers on the auction moors, which do check out Simon's LinkedIn post, it is very entertaining. Where can we find you if we need your salient and excellent advice?
Well, you can certainly find me on LinkedIn, but you will find me at Park Square Barristers or through any reputable solicitor that specialises in occupational stress, of which there are very few. but,
Well,
but
fantastic.
do you know what? I'd like to end our conversation there with something you and I were speaking about just before we hit the record button, which was this advice that I could offer. So two pearls of wisdom. And this goes for the employer and employee as well, I suppose, but to any manager. If presented with a sick note that says stress at work, the one thing you should do and the one thing you should not. The one thing you should do is ask the employee a simple question. You're charged one question. How can I support you? Because if you ask that question sincerely, listen to the answer and act on it, then the chances are you will be absolved of liability and we will never meet. And hopefully also you will have a productive employee who's able to recover and continue in their work. And the one thing you should never do, and I see this far too often, the one thing you should never do is when presented with a sick note that says stress at work, tut and roll your eyes.
Yes, excellent advice.
Because that is going to result in you having to give evidence one day.
How did you respond?
Yes, when presented that sick note, what did you do, sir? Well, I tutted. Yes. Anyway, it
Well,
was
I think
lovely
that's
speaking with you, Hannah.
brilliant piece of advice, and thank you so much for being your entertaining and somewhat horrific stories. It's been lovely speaking to you, and thank you very much.
Enjoy the rest of your day.